All right. So good morning. My name is Marisa Nelson. I'm a wills and trust lawyer in California, and I'm here with Kristy. Why don't you take a moment to introduce yourself?
Hey everyone, I'm Kristy Runzer. I am a financial planner and wealth advisor. I own a financial planning firm, On Route Financial, and have been in the industry now coming up on 10 years. Kind of started in the traditional financial services, which is very male dominated and
Mhm,
just did not have the culture or values that I have. So
mhm.
started my own firm about 4 years ago now, and I'm really working with a lot of high earners, entrepreneurs, leaders in corporate, and helping them to leverage what they're earning and maximize that, turn that into wealth, like turn what they're making into wealth so that they can live the life they want to live, support their family, create generational wealth, give back. And that's why part of the reason I'm so excited to talk with you today, Marisa, is a lot of those planning areas, especially around like helping out family and even saving for yourself and your life and giving back, you can leverage a lot of tools from estate planning in
Yeah,
those goals and that planning. So I'm super
yeah,
excited just to kind of like chat about all of that with you.
yeah, totally. And it sounds like we have some kind of overlapping experience. Also I got licensed in 2011. Boy, my math is like, wait, what numbers now? 2011. Yeah, and I've been focused on estate planning since then. Um, Also a very male dominated field, and not necessarily easy to find a spot where I can really work with my values and help clients focus on the things that I think are super important, like charities and pet planning and focusing on our families and, just the basics that are what most of us are, at least I like to think most of us are focused on. There's plenty of firms focused on high net worth planning, and that's super valuable for those clients. And there's a whole lot of us that doesn't apply currently. So I love just focusing on values and how I can help my clients really maximize what's important to them. So this should be a great conversation.
Yeah, it's so
Um,
important.
yeah. And one more thing about you, where do you help clients? What states?
So I'm virtual, so I can get licensed anywhere. Currently, most of my clients, I'm in Philly, so I have a lot of
Mhm,
PA people, a lot of California, New Jersey.
mhm.
I tend to work with a lot of like coastal big cities
Okay,
type of
awesome.
clients.
Nice. Okay. Yeah, and I guess just to answer that question myself, I'm licensed in California. That may expand soon, but for now, anything I say is focused on California law. Definitely check with someone in your state if to make sure that what I'm saying applies. This is not legal advice, just general information. But yeah, let's dive in because a lot of this does. The laws vary from state to state, but a lot of the bigger concepts and just the background knowledge and knowing where to start applies throughout the US. So, yeah. Well, to get started, do you have anything in particular that's been on your mind? Any questions that we can dive in on?
Yeah, I have lots of questions, but I won't ask you all of them today. But I guess the first thing I'm wondering, so wills, right? That's
Mhm,
kind of like what everyone thinks of as maybe the baseline for an estate
mhm,
plan, right? Like get a
mhm,
will.
mhm.
What scenarios do you need a will in? And or are there scenarios where you don't need a will? Does everybody need a will?
Great question. Um, I would venture to say that ideally everyone 18 and up should have a will. It's probably going to be more basic when you start out and more advanced as you get older, as your situation gets more complex, as your personal wishes evolve, as your assets evolve. Um, and 18 may be a little bit young, kind of as you start to acquire some assets is a good time to look at that. And it's good to talk through what kinds of assets they are and what would happen to those if you're not there to make use of them, right? Some assets, like probably a lot of the ones under your management, you can name a beneficiary, and that covers quite a few scenarios. And in some cases, that might be enough for now. But what that often doesn't cover is incapacity, which is a piece of my work that a lot of people don't really think about. Like, okay, well, what if I die, then this? And a will is great for that. Beneficiary nominations are great for that. But if you're incapacitated and the money needs to be used to care for you, which is a super important piece of this, a will is not going to help at all with that, and neither is a beneficiary nomination. So most people could benefit from a will, but it may not be enough to cover all the scenarios. And there may be situations where just naming a beneficiary is a really good start.
Yeah, that makes sense. Because wills are used to, like say where assets are going.
Mhm.
You don't use them to avoid probate though, right? Or do you?
Correct. In California, at least, and I believe many other states, wills do not avoid probate. So to do that, beneficiary nominations generally do avoid probate so long as the person outlives you. Sometimes we see these situations where they have big retirement account or a small one, which is, just as difficult to administer. People, oh, it's just a little account, don't worry about it. Just as much work to
Still an
go
account.
obtain
Yeah.
those assets. Your family will probably think it's worthwhile. But oh gosh, totally lost my train of thought.
Talking probate,
Yes.
wills.
So sometimes we'll see like there were beneficiaries nominated and then we forgot about the account for 20 years and those people passed first, or like you have your spouse listed and they passed and then you had a few things to deal with in the meantime. It's not like people say, oh well, if we die at the same time, but what if you die at different times and there's this period of time where calling me or calling you is not your favorite thing to deal with. You have grief, you have other more urgent situations to deal with. So often you can name alternates on those accounts, always a good idea. Yeah, so a will does not avoid probate as far as I know in any state, but definitely California. But there are ways to do that, including naming a beneficiary who's living, trusts. That's where trusts come in a lot of the time, and a few other scenarios there. So super important thing to know.
What do you think is the
Yeah.
main purpose of the will? Like what's the main thing that it does? Because there's like a couple different pieces to an
Hmm.
estate plan, right? In
Hmm.
term my understanding at least.
Hmm.
There's
Yeah.
the will, there's the documents, which we can talk about, like if you get incapacitated
Hmm.
or like power of
Hmm.
attorney. And then
Hmm.
there's like the trusts and maybe other
Hmm.
things you can sprinkle in, but
Yeah.
what's kind of like the will's main purpose?
The a will's main purpose is to say who inherits your assets when you die. So it's still a valuable thing. It's definitely better than nothing.
Yeah.
Um, I hesitate to recommend just like writing it out yourself, but if you're like about to get on a plane and you're kind of freaking out, writing it out yourself is better than nothing.
Right.
Cover who should inherit your assets, who should be in charge of your estate, which is also known as the executor. That's the person who's supposed to
Mm,
carry out these things. Who would you choose to do that? That's a super important role.
yeah.
Um, Another thing that, at least in California, is included in a will is who should take care of your kids if you're not able to. So
Mm,
if you have kids under age 18, you want to name a guardian for them, and that is often done in a will as well. So it is valuable and it helps with a lot of things, but there are other options that will help more.
mm.
So I wouldn't say like don't bother with a will. It's just don't stop your conversation or your investigation there and assume that's covering everything.
Right. That covers a lot of good stuff, but not
Yeah,
everything. And that covers the
exactly.
guardianship, it sounds like.
Yeah, and you can also do that separately. In my practice, I do both. I name guardians in the will, and then we also do a separate guardian nomination. They don't conflict. We don't want to have conflicting documents there, but the guardian nomination document allows us to include more details, more what ifs, more contact information, and I think that is a better document to have. Like if you go on a trip and you leave your kids with a nanny or their grandparents or whoever, like leave that separate guardian nomination with those folks. And that's probably going to be not just who you would have care for your kids long term, but it might be like, who do you call in an emergency? And,
Mm,
who would take care of them short term if you're a nanny or whoever's taking the kids for the week. has something come up. So yeah, guardian nomination is super important part of this as well.
Yeah, that's huge because I believe if you don't name a guardian, then the state decides who would take care of your child in the event of your
Yeah.
death or you and your partner's death.
Yeah. So if you know if you have if the kids have biological or adopted parents who have visitation rights or live with them, then they're going to have priority. But it's even if both of you are around, it's very worth nominating who you would choose. And as you said, if you don't nominate anyone, the state via the probate court, the judge is going to decide who
Mm.
should who should your kids live with. And they in California, it's a list of basically closest blood relatives that have priority, and then you see who's able and willing, make sure they don't have a criminal record. But it's beyond that, it's like who's able and willing, and not a super terrible choice based on blood relation, which sometimes closest blood relation is who you would choose, and sometimes it's not, and you should have that right to choose yourself. So how we do that is writing that down in a guardian nomination or in your will. And if you think it's difficult to choose for yourself, like, oh my God, who would take care of my kids if I'm not here? We don't want to think about that situation. But if it's difficult for you to decide, it's going to be so much worse for anyone else to decide for you. A judge who's never met
Mm.
you, who is going based on a list of, like, this is the list for everyone. We look at, your parents, your siblings, like, um, much better for you to be able to decide. And you can name alternates as well if you're worried, like, well, I think this person, but what if they live in a different state or get divorced or it's not a good time for them? We can name alternates, and
Mm.
then you get to have your say all the way down the line. So super valuable.
Mm. That's interesting. I would wonder how that kind of plays out in terms of if you have alternates, right? And
Mhm.
maybe one of the alternates, like, can you name like a bunch of different scenarios to where then that person wouldn't be the guardian and you would go to an alternate? I would
Mhm.
wonder if that gets sticky at all, where when you've named a guardian, but then you have some stipulations and you have some alternates. Like, does that ever get like
Mhm.
complicated in practice
Yeah.
or?
Yeah. I mean, in practice, I don't frequently see people making it that complicated. Um, and part of the benefit of working with me to do this is we can talk through, like, okay, so just, tell me what you're thinking, and then we'll see what makes sense based on my experience. I can advise you, like, hey, that sounds great, but let's simplify this part. Let's clarify that part, because we definitely don't want to introduce any kind of ambiguity or lack of clarity. Okay, it says if this and that, but we're in this third situation that's not covered. We want to make sure that that is not going to happen, and that's part of what I can help talk through and craft craft the language to fit. um so we do want to be aware of things like that. We certainly want to be aware of the reality of, like, um is this going to offend people? But only to a point, right? Like, what we're talking about here is who's going to take care of your kids, and your wishes should be most important there.
Mhm.
We also want to, like, think about, okay, like, how is this going to work in the family? But it doesn't mean that that should dictate what we end up doing. So but I think like, a lot of the caveats that come up there, a lot of the alternates with my clients, so I think, well, these two people, if they're still married, and if not, then these two people. For me, at least, I think that's pretty understandable that there's going to be a lot of reasons why that stipulation might make sense. It might not either. It might really be like my sister, regardless of whether she's married at this point. And that's fine too. So it's not to say that you should have these caveats, just occasionally people want to, and that's totally fine.
Mhm. Yeah, because I think we named grandparents, but then, is there a
Mhm.
certain point where like maybe
Mhm.
they're older and it
Mhm.
doesn't make
Yeah.
sense past a certain
Mhm.
age. I'm just thinking out
Yeah.
loud, but
Yeah, and that exact situation comes up a lot for my clients. It's like, well, I think my parents would be the best choice right now, but should I name them? Like, what about in a few years? And my recommendation is always whoever would be the best choice now and for maybe the next 5 years, go
Yeah.
ahead and name them. Like, let's try not to see too many steps into the future because that's overwhelming and we'll never settle on a best option. Um, and that's part of why we have alternates is like, okay, you write this now, this is the best decision at the moment, but we don't end up needing these documents for 10, 15 more years. And the situations have changed. And by including alternates, you're not only accounting for like, I wouldn't want these people doing it at that point, but it gives them an out as well. Because of course nobody is required to take on these roles that you name for them. And if they are in a situation where they're like, I feel like because of my health, because of I'm going through a divorce, because of whatever situation, I don't feel like I'm the best person, even though I'm nominated. Knowing that there's someone after me who would be an excellent choice, that you know the same person who nominated me also said they're good too. That makes me feel more comfortable stepping down and saying, you know, I'll let the second in line go because this is not a good time for me and it is for them. So it takes some of the pressure off.
Yeah, that's huge. I feel like I see a lot of the aftermath of when someone has passed away and what those
Mhm.
family dynamics can turn
Yeah.
into, especially without
Yeah.
proper estate planning, whether people are fighting a lot of times people are
Yeah.
fighting over assets and the
Mhm.
money or like the car or like
Mhm.
the
Yeah.
something sentimental or
Mhm.
it's challenging. I think it brings up a lot of emotional issues, not only, from the family that's been left behind's perspective, but then
Mhm.
also the perspective of the individual or the couple who is making the estate plan. So like one thing that I see a lot with my clients is they don't want to talk about or plan for their death. They're like, we don't
Mhm.
want to, or they're disagreeing, or they might
Yeah.
be on different pages. I'm curious to hear
Mhm.
your experiences with some of
Yeah.
maybe those kind of emotional things that pop in through the
Mhm.
process.
Yeah. I mean, I find that a lot of folks do have something that's holding them back from getting their wishes in writing. Like, even if they've gotten to the point of calling me, we've had the first conversation, we've talked about what's needed. They know they need this, they want to move forward, and something is stopping them. And I just find it super interesting to try and figure out what that is, both because I'm just curious and also because that then we can help get past that, right? Is like,
Yeah.
you know, is it facing your own mortality? Is there a disagreement over who should be guardian? Like, what is stopping this from going forward? Um, and disagreements with your spouse, if you're married, can certainly be a big part of that as well.
Yeah.
Um, one thing that I would suggest there is to kind of shift your frame of reference and like how you're thinking about this. Like, um, we're not so much planning for death. Like, whether or not we do this is not going to affect whether you're living or deceased or incapacitated. Like, yeah, I
Right.
mean, that's
That's gonna
God,
happen.
your doctor. Like, that's not within my power or anything that we can
Yeah.
um really affect with our work.
Yeah.
But focusing on the planning for life, like, what if you need care? What
Mm,
if your kids need care? um how would you want your assets to be used to provide a good life for your kid, for your spouse, for your pets, for another friend or family member? Like, um the planning that we do is for life, whether it's yours or the people you care about, the pets you care about. um so sometimes that can help kind of shift, like, you know, it's not so much about death, it's about the living.
mm,
And just kind of keeping your eye on the goal of like why this is important. It's about caring for you, it's about caring for your spouse, partner, kids, friends, charities, pets. And if you're gone, like, we can't affect whether you are or not, but we can definitely affect the quality of life for the people and pets and charities that are still here. So um
mhm.
yeah.
Huge. I love that reframe. I love that reframe because I do see it so much. families being torn apart when someone's passed away because
Yeah.
there's disagreements with
Hmm.
who's getting what, or like what someone's wishes
Hmm.
might have been, or because
Yeah.
you're grieving in that state. And
Hmm.
so, you don't want to, or maybe shouldn't be, having to think about
Yeah.
making these very serious decisions that
Yeah.
could have a lot of impact on your life,
Yeah. Yeah.
related to the finances or whatever it is you're inheriting. And so I think it,
Yeah.
to your point, yeah, like you're planning for the care of your family beyond
Hmm.
your life, yes, but like it's still for your family, you're still doing it to take care
Yeah.
of the people that you care about, and the reasons you're building wealth in the first place is
Yeah.
potentially for those family members and causes and charities and
Yeah.
whatever it is that's in your estate plan. But I
Yeah.
love that reframe. And I like to think about it's your legacy as well.
Hmm.
Like I think
Yeah.
legacy is so, it's kind of this thing that feels like, well, like what is the legacy? And it feels like
Hmm.
big and unreachable, but it's like, no, like your legacy is you and everything that you
Hmm.
have, the impact you have made and everything that you've created.
Yeah.
And your estate plan is just preserving and protecting
Mhm.
that.
Yeah. 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 And I mean, whatever we each want our legacy to be, I don't think any of us wants it to be the people we care about most fighting in court for 2+ years just to get things done. Like if you don't have a plan in place and everyone gets along perfectly well despite the grief and everything else going on, that is not a situation that people should be stuck with. And it's, I wish that our system were different than it is. And for now, at least, like our option is to plan to make that better for the people who are taking care of us and our assets and all of those next steps. Like nobody wants to be stuck dealing with court just to transfer your assets to the next generation or to your
Mhm.
whoever you've named, if you've named someone. Yeah, and just and you mentioned grief and the family drama that can come up. Like grief affects us all differently, but it tends to have a big effect. And that's like the worst possible time to be having to make a bunch of decisions, deal with difficult family dynamics, figure out how to do difficult foreign things like administer an estate that most of us have never had to deal with. Um,
Mhm.
the more of that that you can lay out in advance for the people you care about is such a gift to not have to make those decisions while they're grieving. Whether it's like, I mean, the big ones only you can decide is who inherits. And if you don't decide that, then just much like guardian nominations, the court is going to go based on this standardized list of closely living blood relatives. But things like, do you want a memorial service? Do you want uh, something fancy or a cardboard box? Like you don't want your family making those types of decisions while they're grieving and feeling like, I see families feeling like they don't want to scamp on things because it would be disrespectful. But oftentimes my clients are like, I don't want a bunch of like don't spend huge amounts of money on that. Just have party, celebrate my life, spend time together. Um, and those kinds of reminders can be super valuable as well, just not having to decide a million little things about the service or any other part of it that you can avoid when you're grieving is such a gift.
Yeah, I love that. So that's our pitch to get your estate plan done, right?
Yes,
That's my pitch
absolutely.
to you all, to get it
Yeah.
done at least.
Yeah.
And but
Yeah.
one thing I'm curious about too is trusts and how
Mhm.
they fit in, because I feel like there's
Yeah.
so many different types of trusts. They do
Hmm.
different things.
Hmm.
Where do we start
Yeah.
with trusts?
Yeah. Yeah. So I do think that's part of what holds people back too, is like trust sounds so complicated. There's lots of different ones, and you hear about it with like the ultra high net worth people, and that's a whole different thing. There are different types of trust, and for most of us, we need a revocable living trust, which is a lot like a will or what we think of as a will, but it just does things a little bit better for us. It helps us with more of what we want to have happen. Um, So when I refer to trust, I'm usually talking about revocable living trust, even though you're totally right. There are a bunch of types. So a revocable living trust, you're not committing to anything permanently. You can change it anytime you want to. And I think that's a big thing for people as well. Like, you don't have to know the future. You're not giving away your assets or tying them up permanently. Like, if you want to create a trust that provides for your kids down the line, you're not like, with a revocable living trust, you're not like committing those assets to this plan or yourself to this plan. Like, you're still controlling your own assets, managing your own assets however you like. And then you're setting up this trust that says, if I'm not able to manage them myself anymore, here's what's going to happen. So you're not locked into that. You're not committed to these people inheriting, these people being in charge. You can still use those assets for your own life. And life changes, and like a revocable living trust expects that. It allows for the fact that your assets will change, your plans will change, your family members will change, like all of that changes. So you're not stuck with whatever you put in place there. Yeah, so that's the most common trust. Right now we're in a pretty lucky period of time as far as the tax laws are concerned, because a lot of it does go back to tax laws. So we have each state's probate laws and then the federal and state tax laws that kind of impact trust planning. But right now, the federal estate tax exemption is over 12 million per person, which gives us a lot of flexibility to just go with a revocable living trust and not even look at some of these more complex planning options. Certainly, higher net worth people will want to consider their options, even if they're not quite there yet, just to see, like, okay, as our assets grow, what should we be thinking about? That estate tax exemption can change and quite possibly will in the next few years. So it's something to keep an eye on. But right now, most of us don't have a need to look at these more complex trusts, which I think can help narrow it down to, okay, we don't need to worry about any of that. We're just talking about who inherits, who's in charge, what's most important. Like, if I'm leaving money to my kids, a trust allows you to say, like, I want their education to be paid for, their medical expenses, their health care. But I don't want them to be able to go buy a Ferrari quite yet. Like, let's put some limits on this. So you can provide some guidance with a trust that is much less doable with just a will.
Yeah, I remember setting up the trust. So I have the trust, the living trust, the will, and then like the guardianship and those type of
Awesome.
things. And I kind of forget what went into the will and what went into the trust. So that's
Mm-hmm.
helpful. That clarifies,
Yeah.
because I'm like, should I be updating this plan? Because it has been a couple of years. I've had another kid since
Mm-hmm.
then, but
Mm-hmm.
sounds like, at least trust wise, living trust is kind of the main one until you go beyond that, either 12 million net worth as an individual, or if you're
Mm-hmm.
married, 24, right?
Yeah, exactly. Yeah,
Um,
and as far as updating, I would just look through on your own and see, like, first off, who you've named in the documents that you do have. Like, are those still the people you would choose?
Not all of
And
them are. I
then,
already know that.
yeah, yeah. So that's the biggest reason we see to update, and how urgent
Mhm.
that feels is kind of up to you. But and then the other piece you mentioned, you've had another child, so there's different ways to draft. And when I draft a trust, I'm always saying, um, equally to my kids, unless the client doesn't want any reference to possible kids. But if we have kids, if we may have kids, if there may be more kids, we want to account for that up front, so that you're not having legally to immediately call me and say, hey, we need to add another beneficiary here, or they're going to be left out. So hopefully that younger child is already accounted for there,
I
but that's
think
an
it
important thing to
is.
check.
I'm pretty sure. I'm
uh,
pretty sure that's how we worded it.
Perfect.
But I also think we set up how we want the money distributed. So like that was one of the things I remember was, okay, if you pass away, maybe I guess before, either before they're 18, or no, I guess before 18, it was just kind of more like we want it to go to education and this type of
Mm-hmm.
stuff. But then after 18, it was like, if we passed away, when they would get the money. It
Mm-hmm.
was like, and I think we said like at, in their 20s, they'll get a third, in their 30s, they'll
Mhm.
get a third, something
Mhm.
like that. Is that what you
Yeah.
do with the trust? Like those types of things?
Yeah. Yeah, exactly. That's definitely something that I present as an option to my clients, and I think it works well to have that kind of staggered, like, financial management skills are not, like, magically bestowed at a certain age, right? So, staggering the distribution can help give them a chance to learn some more financial skills. You're not handing off your entire life savings all at once. And that's a big benefit of a trust, is being able to set those ages. It's not automatically at 18, good luck, here's all of it. Um, and it's not like use it for whatever you want. It's this person is going to manage the assets for my kids until they're this age, and here's how I want them to prioritize those funds, education, etc. And it gives you a lot of ability to continue providing some of that guidance that hopefully you'll be here to do yourself in person. But if not, we can at least add that to the trust, and make sure that our priorities are accounted for and how those funds are used.
Yeah, that makes sense. I know that was like the one area I think that we personally disagreed on was well, when and how much of the money would be distributed.
Hmm.
I think my husband wanted all of the money to be distributed at once or something.
Hmm.
And I think I did the stagger approach, but it
Yeah.
depends too, because it's like I
Yeah.
hear clients who are like, well, this child's really responsible. I have no
Hmm.
problem giving them the money. This child maybe would
Hmm.
would benefit from a staggering approach,
Hmm.
or
Yeah.
I guess that could change. That might be something you want to update and change as
Hmm.
their
Yeah.
personality. I have little kids, so as their personalities
Yeah.
develop more, but
Definitely. Yeah. And I do think that that is one of the most common things both to disagree on, because I think it focuses a lot on like our own personal experience and how much we trust our kids' financial skills like 20 years in the future, right? But you can update it, and you probably will want to around that age anyway, because either, if you set it now, you're saying, okay, like 25, 30, 35, whatever it is, that's when I will feel comfortable with them having more control. And then as you get closer to those ages, you'll not only have a much better feel for how their financial skills have developed, and also maybe their relationships, because that can play into it too, right? Like, I totally trust my kid, but I don't trust the person they're with. That can be a part
Mm,
of it. But as you get closer to those ages, you can know more about them, know about their relationships and their financial skills. And you're probably going to want to update around that time anyway. If they're doing great, you may want them to be named as the trustee and in the other roles by that age. So that's one of the most common things I see for why people update estate plans is create it when the kids are young. Now they're responsible adults with careers and relationships and whatever else. And we don't have to like try to see the future 20 years from now anymore. We can say, okay, here's the actual situation that we're planning for. Um, yeah. So try to plan as best you can for right now and the next 5, maybe 10 years. And then beyond that, just know that you're going to revisit and possibly make some updates. And it's worth it to
yeah.
just know.
Yeah, that's a good mindset to go into it with, because you can't plan out every scenario or know what's going to
Mhm.
happen so far in the future. So focus on a 5-year plan and then update if you need to.
Yeah, yeah.
Yeah, I think that's good. Good advice. What about if you're wanting to leave money behind for charity, or you want to
Mhm,
give, do you recommend using trusts for that, or do you just like maybe designate beneficiaries on that, or like how do you kind
mhm,
of work in giving goals to
mhm.
someone's estate plan?
Yeah, there's a lot of different ways to do that. I think it depends on the client's goals, what types of assets they have. It's a great time to include the financial advisor in the conversation, um, because depending on what the assets are, there's different tax rules, there's different short and
Mhm.
long-term impacts. Trust can be a great way to do that. Everything from we want to give millions of dollars to charity and we want that to happen over an extended period of time. We want some income tax benefits from that. We want to benefit ourselves and the charity, or our kids and the charity. There's lots of ways to do that with trust, especially with larger donations. On the simpler end, it could be, I have a couple $1 million, a house, 401k. I want most of it to go to my kids, and also 10% to my favorite charity. Just when I die, kids, charity, done. And you can do that just as part of a regular living trust without any of the complexities. If you're making gifts during your lifetime, that doesn't necessarily need to be accounted for in your planning, because you're here to say, okay, this year I'm going to give this much and this is how I'm going to do it. There are donor advised funds, which can be a great way to do that and preserve some flexibility. One more thing I was going to mention about that. And then of course, beneficiary is totally separate from wills and trusts. If you have an IRA or a 401k that has a lot of gain built up in it, those can be great assets, as I'm sure you talk with your clients about, to donate, because charities have better tax impacts than individuals. So sometimes it makes sense just to say, this charity is listed as the beneficiary on my IRA, or one of the beneficiaries on my IRA or 401k. So yeah, lots of great options there. And it's important to kind of talk through your goals and the types of assets you have with your estate lawyer and your financial advisor.
Yeah, that's one where you really kind of need that personal plan, it sounds like. Yeah, that makes sense. I think giving is definitely something that can be underrated if it works in your finances and with your goals. But giving being essentially, gifting the max limit to kids or family members or charities while you're living instead of when you pass. So this is kind of a way I've been starting to think about like my legacy and estate plan. Is like, I want to also see my children and the causes I care about enjoy the money while I'm living. So I can start passing some of that on, earlier than the estate plan might officially kick in. Do you see people doing that at all? And it depends on everyone's situation. And I'm not doing that right now. I'm saving more and building the wealth. But when I am distributing the wealth, that's my goal and my plan.
Yeah. And that can be a great way to give over time, like you said, whether it's to your kids or to a charity. Once you're at a point where you feel comfortable with what you have and you don't, you can give some away every year and not be concerned about your ability to care for yourself. Giving as you go can be a great way to do it. You can gift 15 grand a year per recipient and not have to file any tax returns about it, not have to, obviously talk to your CPA about these rules, but you can gift that 15K a year per person without having it affect what you can give at death and not pay taxes on it. So it's a pretty good way to go. And as you said, if you want to see some of those benefits start to happen during your lifetime, so you can see people enjoy it, that can be a good thing to consider as well.
Because I talk with my husband about this all the time. It's like, at least like in our example, like, we need the money like now when our kids are young and we're like, saving for their education, and as opposed to like if I were to receive an inheritance when I was in my 70s or something, it's like that's not going to have as much of an impact on my life as it would having some extra income now while my expenses are extra high because of raising kids and whatnot. So it's just something interesting to think about. And obviously there's no right or wrong and everyone can set it up their own way. I'm just sharing some of my own personal experiences and goals, but there's a lot you can do. There's a lot you can do is kind of one of my takeaways, is like you can just talk it all out, see what your options are with a professional, and they can just do what needs to be done to set it up so that your wishes are carried out.
Absolutely. And I think that's one of the big benefits of working with an advisor, whether it's an estate lawyer like myself, financial advisor like you. The client can come in and say, here's what I have personally and financially, here are my goals. What are some good ways to achieve that? What are some things I haven't thought about? And we can present like, well, have you thought about this? Did you know you can do that? And we can um, narrow it. Like if you just do a Google search, you're going to get all these ideas that might not apply to people in your state, might make no sense at all for people with your assets, doesn't point out that, hey, your kids have this need that's not accounted for here. But if you go to an advisor, you can see like, okay, for me, for my situation, here are three things that I should be thinking about. What do I prefer from those? And I think that's super
Mhm.
valuable because I sure don't have time to go research every possibility under the sun that doesn't apply to me. Um,
No, no
yeah.
way. I've definitely have hired and will be hiring again an estate attorney because I know in financial planning how many rules there
Mhm.
are and laws
Yeah.
and guidelines. And so
Yeah.
it's a whole other realm of that.
Yeah. Yeah. Absolutely. And like, how many of us have tons of spare time right now at this? Like,
No
even,
time, no interest.
yeah, no, energy is a big thing, right? Like, even if we have the time, do we have the energy to take on an extra project without someone like
No,
guiding us through it? I don't. Even
I
at the
know.
beginning, you remember like March 2020 when everyone was saying like, "Oh my God, now I have all this free time." I never had that. I'm not sure who those people were, but I don't think they had kids or their own business or I guess their job disappeared, which is not something to take lightly, but yeah, I did not feel that like, oh, free time feeling ever.
No, and even if I did, I would not want to spend it in that way.
Hmm.
I'm not going to be doing legal things in my
Right,
free
right.
time. Yeah. No,
Yeah,
this was super
yeah.
helpful. I really appreciate all your guidance and it's nice to have someone just break it down for you.
Hmm.
It's like
Yeah.
when you're googling all the things, there's like all the lingo and all the
Hmm.
terms, and so I appreciate you just kind of breaking it down.
Yeah.
Lots to think through and talk through, but it's a worthwhile process because it's like, why are you working so hard to earn, and then you're working hard to build up your assets and your wealth, and then you know the passing of that
Hmm.
is important, and
Hmm.
in the grand scheme of things doesn't take a lot to set up, but
Yeah.
can make such a huge impact and such a huge difference
Yeah.
on your finances. But really, especially in estate planning, it's kind of like as you're passing that on to the next generation, and
Hmm.
especially if generational wealth and um, leaving an inheritance is important, then to me it's like a no-brainer process,
Hmm.
because if I
Hmm.
can pass on more wealth, be efficient with my taxes, and save my family the emotional headache of having to deal, they're already going to have stuff to deal with because you're already
Hmm.
having to at least
Yeah.
administer the estate and do paperwork
Hmm.
and call up the financial institutions and get the money
Hmm.
transferred and do all the things. So it's like the
Yeah.
more I can
There's
take
plenty.
off, there's so much. I've seen it in action. It's a lot.
Yeah.
And while
Yeah.
emotionally grieving,
Yeah.
it's a lot for the people who are kind of
Yeah.
left behind to settle things.
Yeah.
So the work you do is
Yeah.
so important and so needed.
Thank you. And you as well. Like there's a lot that we can do to make the process easier for our clients now and make it easier down the road and just, you know, all parts of this benefit from being simplified and made more approachable and both of us can do a lot for our clients that way. So um super satisfying.
Mhm. Mhm.
Yeah. Well, thank you for your time today. Anything else that you wanted to discuss?
I think that was all of my questions. Yeah, I think so. I'm
All
trying to
right.
think. Did I forget anything? I think that was it. Super
Cool.
helpful. Super, super
Yeah.
helpful. Thank
Great
you.
topics. We'll pop your information in the caption. And yeah, thanks for spending time today.
Yeah, it was my pleasure.